Hello, I'm Don Trapnell, one of the two directors of Synchron. You know, a lot of people feel that running a business in a compliant manner is a hard exercise. It's not that hard. The purpose of this presentation is to assist you in conducting your business the Synchron way. So you've applied for a Synchron authority, you're ready to start. What do you do now? How do you do it? How do you run your business so that you're compliant with the Synchron process? Now, we try to make it easier. Why? We know if we have a compliance process that is not hard for you to follow, your clients benefit out of it. We're going to cover items such as your financial services guide. We're going to go through the best interest duty obligations and how they translate to your processes and advice documents and record keeping. We're going to look at how you need to complete your Synchron statement of advice, which is probably very different from the statement of advice that you're used to using with your current licensee. And we're going to look at the time-critical instruction to proceed. And we're also going to have a look at a Synchron unique document called the post-appointment letter. Now, we are sure you do a post-appointment letter of some sort to a client after you've seen him. There is a particular way that we would like you to do it, which will protect you and protect your client. We'll also cover some of the other rules and regulations which apply to your business and give you some guidance about what to do when things go wrong. And before we do all that, let's set the scene by considering what is compliance and what is advice.
Hi, I'm John Prosser and I'm the other director of Synchron. Welcome to Compliance at Synchron. I'll start with the big question, what is compliance and why is it important to me? Well, it's important to you and to Synchron for a number of reasons. Financial advisors in Australia operate in a heavily regulated environment, which is another way of saying there are lots of rules. In order to ensure that the rules are followed, licensees like Synchron are required to have systems and controls in place to promote compliance, to ensure that our authorised representatives understand their obligations, and to supervise and control their activities. Ultimately, while Synchron can develop policies and procedures and provide you with the advice, we're reliant on you as the providers of our financial services to do the right thing and to take your regulatory obligations seriously. At Synchron, we place confidence in you to run your business in a compliant manner. We try where we can to avoid meaningless restrictions and red tape, and that confidence is available to you as long as you can show us that you take compliance seriously and that you know what you need to do. Yes, the laws are complex, but the reality is that our regulators and clients expect that we provide our financial services efficiently, honestly, and fairly, and that we know the rules.
As in most of the industry, Synchron conducts regular audits or advisor reviews, if you want to call them that. You will have a compliance consultant or auditor assigned to your practice who will be in touch with you shortly after you start. These auditors are usually people who have worked in the industry just like you. Please use them as a resource to talk about the things you're doing. The intention of the audit is not to catch you out. The intention is to review your advice and your practice and identify any possible risks that may lead to problems with clients, problems with Synchron policies, or losses to your business or ours. Our number one goal is education, so please approach the review with that in mind. Penalising or revoking advisors over unimportant matters is a very poor way to run a licensee, and that's not our intention. But do keep in mind a couple of things. If you are worried about something and don't tell anyone, you'll never get help. If you don't answer questions or provide information, we're likely to get the wrong idea about your business. If we ask you to do something, we expect that it will get done. After each audit, we will determine whether you need to be revisited again in 3, 6 or 12 months, depending on what the audit identified. We will work with you to resolve issues, provided we can see that you're working with us.
Remember, the purpose of an advisor review or compliance audit is not to catch you out. It is to assist you to fine-tune your processes and help you with your practice management where we can.
As you would already be aware, it's important for you to keep your knowledge and skills up to date. The regulator expects this, but more importantly, you can't service clients if you're not on top of things. You're responsible for ensuring that your training is up to date, your ongoing training. You have access to the excellent Kaplan system, but also think about other conferences and training sessions you can attend, because this sort of in-person training is often more valuable. Finally, Synchron runs 3 professional development days in each state each year. These are compulsory for advisors to attend, and your attendance is monitored.
Hi, I'm Michael Jones, Compliance Manager for Synchron. At Synchron, we recognise that there's a lot to remember. This is a very complex environment, but there's always assistance available. The Authorised Representative Policy and Procedure Manual covers just about everything you should need day to day, so stop there first. It's on the website and we send you a copy. If the manual can't answer everything, it'll usually refer you to where to look. And you can always ring your state manager, your compliance reviewer, or Synchron Compliance at head office. If you're not sure about whether something is compliant, it is always better to ask the question. So before I get into the detail of the rules, here are my major takeaways for staying compliant at Synchron. Number 1, if you are concerned about something, don't keep it to yourself. Help is always available. Number 2, you can usually make good decisions by thinking about the client's interests. The client's interests are paramount. There's a test for ethical decisions which you may have heard of, which is called the front page test. If you're not sure whether or not to take an action, think about it appearing on the front page of the newspaper. If you wouldn't like that idea, it's generally a good sign that you shouldn't be taking that action. Number 3, to steal a catchphrase, if you see something, say something. As a licensee, we're expected to manage problems, breaches, and complaints efficiently, and we need to learn from them. If you see something going wrong, you need to tell us. And finally, to reiterate, the survival of your business and Synchron's is dependent on you taking compliance seriously.
You probably have an idea about what the word advice means, but this is a compliance video, so let's look at the regulatory definition of advice. Financial product advice is any recommendation or statement of opinion that is intended to influence someone to make a decision about a financial product or a class of financial products, or could have that effect. So what does this mean exactly? Financial products are, broadly speaking, instruments that allow a person to make an investment, like shares or managed funds, or manage a financial risk, like insurance. Some things are not financial products. Loans other than margin loans, for example, and residential property, which is why you are not authorised by Synchron to give advice on these things. A recommendation or statement of opinion should be pretty self-explanatory. This excludes statements about objective facts. The last part. influencing the person to make a decision about a financial product. It is very important to note that you don't have to intend the statement to have this effect. You need to have regard to how the client may interpret the communication. Keep in mind the context in which you are speaking to clients. You are a professional financial advisor. When you express your opinion about something, it is going to influence most clients into making decisions.
So that is advice. Now there are two types of advice: general advice and personal advice. General advice is a recommendation or an opinion which is not directed at a particular client. Think about research reports, PDSs, advertisements, and the advisors you see on TV shows or in the newspapers. General advice must always carry a general advice warning, and you will have seen a lot of these. For example, this advice is general in nature and does not take into account your personal circumstances and needs, for example. The goal of the general advice warning is to make it clear to the client or whoever is receiving that advice that what you're saying is not personalised to them, and that's very important. Where a recommendation or opinion is directed at a particular client, it will be personal advice. This includes where you have considered the kind of advice a particular client needs, their objectives, or their current situation, or anything else that tailors the advice to that person. Personal advice is the type of advice which brings about most of the key regulatory obligations. Advice documents such as statements of advice or records of advice, and also key obligations under the Future of Financial Advice or FOFA legislation, including the best interest duty. So please do remember that the requirement for an SOA is based on advice and not on transactions. Anytime you give personal advice to a client, you need to consider your advice document obligations.
Let's start with the Financial Services Guide. And it's important to know that it is unique to you. You can't actually ring up another advisor and say, "Can I borrow your Financial Services Guide? I've run out." Because your Financial Services Guide is designed for you. And when do you hand it to your client? You must provide the Financial Services Guide to the client at the first opportunity to do so. Well, now you can do it electronically as well, so you don't have to always do it in person. The way I handle it is I say to a client, "This is my Financial Services Guide. It tells you a little bit about me, a little bit about Synchron, the company I represent, and it tells you how we respect your privacy. Would you please sign this document just here, Mr. Client, as an acknowledgement that you have received it." So it's not that hard, is it? Your Financial Services Guide also identifies the areas in which you are authorised to give advice and how you will be remunerated. And that's why I said earlier, the Financial Services Guide is unique to you, because different people have different levels of authority. When you're with a client, hand him the Financial Services Guide and leave the full guide with the client. The insert, however, is a 2-page insert. The first page is your details. That's personalised to you. The second page is the receipt, and that's what you have to get the client to sign. You retain it on your file. So when the audit happens, when we send our auditor around to have a chat, we're going to be expecting to see a signed receipt. Alternatively, if you sent it by email to the client earlier, say when you made the initial appointment, we want to see a copy of that email on file. You can then sign the receipt yourself, noting when the FSG was sent to the client. We also recommend that you regularly review your Financial Services Guide to make sure it correctly reflects you, your business, and your business, and the fees that you charge. Fact-finding and data collection, obviously any advice needs to be in the client's best interest, and therefore you must identify your client's objectives. Once upon a time it was fine to get a writing pad out and take down notes. These days it's a bit more complex. These days we need to have a format in which we can follow to cover off on all the things that a client needs to tell you so you can meet your best interest duty. That's what we call the fact-finding process.
Now let's talk about statements of advice, or SOAs. As a financial advisor, your product, what you're selling, is your financial advice. So it makes sense that the SOA is probably the most important thing that you produce. For this reason, and of course the various regulatory requirements, it's vital to get these right. This means that making sure that your SOA reflects all the great work you've done, and that it's clear, concise and effective for the client to read and understand, and that you've checked every I is dotted and every T crossed, that all the figures are correct, and that it looks like a great product. The Synchron SOA templates that we will provide to you help you to meet your obligations in a document that is clear, concise and effective. The 8 safe harbour steps in the best interest duty dictate what we must do, and we'll take you through those steps shortly. But in essence, we believe you need to consider 4 simple steps in the advice process. Step 1, why did we see the client, or why did they come to see us in the first place? Step 2, what are we going to do about it? Step 3, how are we going to do it? And step 4, does it satisfy why the client came to see us in the first place? If you've received an application pack from us, there is a 1-page document in that explaining the Synchron 4-step statement of advice process. And it also reminds you of Synchron's requirement for a post-appointment letter when life insurance policies are affected. We'll discuss that later.
The number one most important piece of regulation for you to know about when advising clients is the best interest duty. The best interest duty came in with the FOFA legislation and replaced the old requirement for advice to be suitable. The bar is now much higher, and it is a particular focus of our regulator ASIC in implementation of the FOFA legislation at the moment, with a couple of high-profile cases you may have seen over the last year. The basic rule is that personal advice must be in the best interests of the client. So what does that mean? Well, to help advisors understand what they need to do, the legislation sets out 8 safe harbours. If you tick off all of these, you'll be taken to have acted in the best interests of the clients. It's like a roadmap to compliance with the rule. Keep in mind as well though, that ASIC has now made it clear through the issuing of a class order that it needs to see evidence of completion of these safe harbours. So in other words, if you want to be able to rely on them, you'll need to be able to produce clear evidence that you've ticked off the box. To help you meet this requirement, Synchron has a best interest duty checklist, which must be completed with each advice and retained on your client file. We'll take you through those 8 steps now, but if you want to know any more about any of these steps, please Google RG175. It's a really useful ASIC regulatory guide which not only explains every step of the process, it also includes practical examples of how you apply each safe harbour on a day-to-day piece of advice. So step 1, data collection, which Don's already referred to. The advice provider, which is you, must identify the objectives, financial situation and needs of the client that were disclosed to the provider by the client. So how do you do this? You need to perform a fact find. At Synchron, a written fact find is now compulsory. We have a standard template that we prefer you to use. If you would like to use something different, you need to seek out pre-approval. And when the fact find is completed, it needs to be saved on your file where it can be easily located. You should also think about how your statement of advice reflects the information you've collected about the client. You can reflect back the investigation that you've done in the statement of advice and talk about what you've learned about the client. Step 2, subject matter of advice. You must identify the subject matter of the advice that has been sought by the client. This is also called the scope of advice. So again, how do you identify the scope of the advice? Why did the client come to you in the first place? It's the first step of the Synchron 4-step process. You need to probe the client for their needs. We've seen instances where ASIC has penalised advisors taken a cookie-cutter approach to advice, giving every client the same advice without considering their individual needs. You should also consider other matters that the client hasn't specifically asked for, but which are relevant. So, for example, if the client has come to you asking about income protection insurance, maybe they've seen an ad or it's mentioned by a friend, but you notice that they have no life cover and would benefit from advice on that product, you should talk to the client about including that in the scope. Your statement of advice must clearly outline the scope of your advice, and you should also explain how you arrived at that scope. Step 3, this is about determining relevant personal circumstances. This step is about connecting the first 2 steps. Out of all of the personal circumstances information you have collected, which of that is relevant to the scope of the advice that you've agreed with the client? So for example, your client's health is likely to be relevant in relation to insurance advice, but not as relevant to the selection of investment portfolio. As always, think about evidence that you've done this step. So reflect in the statement of advice what key personal circumstances you've considered and what those circumstances have dictated for the advice. Step 4 is this requirement around reasonable inquiries as to completeness and accuracy of information. The requirement is that where it is reasonably apparent that the client information you've collected is incomplete or inaccurate, you're expected to take positive steps to correct that issue. This is a higher bar again than there has been in the past. You cannot simply proceed in the absence of important information. If vital information is missing or seems wrong, don't proceed to advice. If advice is still possible but with limitations, you need to explain this clearly to the client, and you should evidence their agreement, such as in the SOA. Keep in mind that clients often don't know what their relevant personal circumstances are. The expectation is on you as the advisor, the one with the experience and the qualifications, to take the client on this journey. We have seen advisors sanctioned by ASIC for failing to push clients hard enough on data collection. Advisors where all of their advice seemed to be to clients who hadn't provided necessary information. Don't be one of these advisors. Step 5 is around expertise. The requirement is that you must assess whether you have the expertise to advise. Put bluntly, are you 100% confident you know what you're talking about? This expertise must relate to the specific subject matter of the advice, the particular type of product, for example. Expertise includes your professional qualifications and your experience and skills, but also the authorizations on Synchron's AFSL, a license from ASIC, and your authorizations from Synchron. If you're giving advice outside of what we're licensed to give, or what we have authorized you to give, you may find yourself in trouble. Again, declining to advise a client is always an option, as are referrals to other experts. Step 6 is the product investigation. Where it's reasonable, given what you've considered about the client, to consider recommending a financial product, you must conduct a reasonable product investigation. This is part of the Synchron 4-step process. How are we going to implement what the client needs? So what does this reasonable product investigation mean? Well, you'll probably be happy to know that it doesn't mean you need to investigate every product available in the market. However, if the client requests you to advise on a product, or you feel that you should because the client's got that in their portfolio, for example, then you need to investigate that product before you can give advice. With your investigation, keep in mind that while you may rely to some extent on third-party sources, like for instance Synchron's approved product list, research reports or marketing material from a product issuer, the responsibility remains with you to determine whether the sources are reliable. So consider whether the research house is one that you've used before, or whether they may be conflicted in the advice that they've given. How do you evidence your product investigation? Well, there are a few different ways you can do this, and it is important to consider each time. Your statement of advice should reflect what you've considered and what you have selected and why you've selected that product. You should also think about what you retain from the investigations that you've conducted on your client file, such as product comparisons from software, which can be very useful for quickly comparing different products, different policies and their costs and features. This is a really important piece of the puzzle. If ASIC sees an advisor giving the same recommendations to multiple clients, they have already said that they will scrutinise that situation, and you would want to be armed with lots of evidence for your recommendations to show that you've done your product investigation and that you have a really good reason for the product you selected. Step 7 is one of the potentially more confusingly worded ones. This is where you must base judgments on the client's relevant personal circumstances. And helpfully, we spoke about the 4-step process. This is about reflecting on, has the client achieved what they came in to see you for? The advice you give must ultimately leave the client in a better position. All judgments you've made regarding the scope of the advice that you've set, the recommendations that you've made, the financial products that you've considered and the alternative, all of these judgments must be based on what you know and what you have collected about the client. So in other words, at the end of all of this work, does your recommendation satisfy why the client came in to see you in the first place? And again, think about how you can reflect on this in your statement of advice to help provide evidence. Now finally, step 8. This has also been known as the catch-all safe harbour. You must take any other steps which are in the client's best interest. So think of it this way. Are you 100% comfortable that client is leaving your office with the advice that they need and that they will be better off for having received the advice? ASIC has set out some of the things you can think about under this safe harbour. Does the client fully understand what advice has been provided and also what advice hasn't been provided? Do you need to explain in your statement of advice that you haven't dealt with certain areas? Think about setting review targets. Explain to the client that they may need to review the advice after a particular time period and maybe diarise a follow-up for yourself. And in particular that they may need to review their advice if their circumstances change. And also think about what else the client might need advice on or might need a referral for, but they haven't asked about, but that you think would be important to them. And remember, if you're not authorised to give that advice or you don't feel you've got the expertise, you can always consider referrals.
Shortly after you receive your Synchron authority, your compliance auditor will conduct an induction meeting with you to take you through your Synchron SOA and how to use it. We'll also check your first 5 SOAs after you join us to help you to fine-tune them if necessary. So don't feel like you're out there on your own. As always, help is available. I want to move on to file notes. We've spoken already about the importance of keeping records for compliance with the best interest duty. It's critical that you are keeping good quality file notes of all of your interactions with clients or potential clients. Why? Well, for a few reasons. Firstly, you need to keep records for regulatory reasons like the best interest duty. Secondly, because they're crucial in the event of a dispute or a complaint by a client or a problem with a client's insurance claim or a product that they purchased through you. Finally, and most importantly, because by having a good record of the interactions you've had with your clients, you'll be able to serve them better. So what makes good file notes? Well, they must be timely, created at the time of the interaction or as soon as possible after. Reconstructing old conversations is difficult to do and less useful. They must be sufficiently detailed so as to explain the interaction, who was involved, what was said, What were the action items arising from the interaction? They must be easily located when needed, so file notes which are held on a particular client's file in date order are best. If they're electronic, they still need to be easy to locate and related to that particular client. Try to keep in mind that others may need to read your file notes. The regulator, our auditors. So make them comprehensive enough that someone who wasn't there at the time will still understand what happened. And if they're handwritten, please keep these other readers in mind. They need to be able to read your writing. Look, it could be as simple as a post-it note or just a scrawled page. Make sure it's legible and keep everything.
Can I talk briefly about time-critical instruction to proceed? You may occasionally find yourself in a situation where the client instructs you to proceed before you've had an opportunity to prepare and present the statement of advice. The legislation provides for this by allowing you to do a time-critical instruction to proceed, provided the client signs it. This instruction sets out the client's instructions and full disclosure of the remuneration you receive for the service. You don't have to be dollar perfect, but you do need to have a good estimate. If anything, go a little bit over, because it's better to overestimate than underestimate your remuneration. Synchron provides a very simple one-page document once you get authorised for you to use. You are then required to present your client with their full statement of advice within 5 days. Now that's 5 days, not 5 working days, believe it or not. It's 5 days. So if it's Friday night, Saturday, Sunday is 2 of those 5 days. Keep in mind that the time-critical process should only be used in exceptional circumstances, and quite frankly, we don't really want our auditors to have a look at files where every single client is done under a time-critical. You should usually be able to provide the client with their SOA and give them time to read it properly and ask questions before applying for the insurance and other products. There is a letter called a post-appointment letter that is a requirement of Synchron, but not a requirement of ASIC or any other regulatory bodies. It's a letter which Synchron asks you to send to any client who takes out insurance. It thanks the client for effecting their insurance through you. It notifies them that you're enclosing a copy of their personal statement and their medical information that they've given you, and it asks them to read it once again and notify you if any of it is incorrect. It also tells them of their ongoing duty of disclosure, which means that once an application is completed and submitted to the insurer, the client must notify the insurer of any change to their medical or personal circumstances, in order that the insurer can then look at the changed circumstances and see if the application is still acceptable at standard rates on the basis submitted. Or do they need to make a modified term of acceptance? This is a very important document because it creates a paper trail whereby you can demonstrate, in the event of a complaint, that you have notified the client in writing that you have asked them to review the medical history given and any other details, and ask them to notify you if anything is incorrect. This document doesn't mean you'll certainly win a complaint. However, it can demonstrate that you have a regime in place whereby you provide clients with all the information they've given to you and to the insurer, and it gives them the opportunity to correct any inaccuracies. And it will go a long way to improving your credibility. You know, in the event of a claim, a disputed claim, where the claim is rejected or modified because of non-disclosure, it is a very common thing to come across where a client will say, I told the advisor when we filled out our personal statement about this particular condition. And he wrote it down. I know he did. Well, by sending the post-appointment letter out, enclosing a copy of the application, it gives the client the opportunity to, number one, correct any misconceptions about what he told you. But number two, in the event of a claim which is challenged, it lowers the possibility of a client blaming you, the advisor. We provide this letter when you're appointed. There is a slightly modified version covering the situation where the Life Office obtains the client's information and sends a copy of their answers directly to the client.
FOFA legislation is not just about the best interest duty. It also targets some of the other behaviours and practices in the industry which were leading to client losses in the past. This includes situations where clients were paying ongoing fees to advisors but not receiving any services or receiving inadequate services, sometimes even forgetting that they had the arrangement at all while still paying a fee. This is the regulatory reasoning behind the Fee Disclosure Statement, or FDS, and the renewal notice, or opt-in, rules which came in through FOFA. There's some complexity and detail to the law, and we explain this more in our manual, but the basics are as follows.
Where you have an agreement with a client under which an ongoing fee is paid for personal advice, you have what is called an ongoing fee arrangement. Where an ongoing fee arrangement exists, you need to comply with Fee Disclosure Statement and renewal notice obligations. Synchron cannot do this for you. These documents reflect the services you promised your clients and what you gave them, and Synchron don't dictate these. The FDS is a document that explains to the client the fees they paid under the arrangement during the last 12 months, what services they were entitled to receive for those fees, and what they actually received. There are some tricky rules around setting the dates, whether you use the anniversary of the client relationship or some other date, and we can help you with these. Also, please keep in mind that the FDS is required for all of your clients. Renewal Notice. The renewal notice is a document that informs a client that they may renew their ongoing fee arrangement with written notice back to you, and that if they don't give this notice, then their ongoing fee arrangement will end. It needs to be sent at least every 2 years, and the idea is that it should be sent at the same time as the FDS, so that the client can see their fees and services and make an informed decision. Where it differs from FDS is that it's only required for newer clients, which are those who started their ongoing fee arrangement after 1st of July 2013.
So why are these documents so important? Well, under the Corporations Act, a failure to send your FDS or to complete the renewal process within the required time frame is actually taken to end the ongoing fee arrangement. Now, as you can probably imagine, when the ongoing fee arrangement ends, so does your legal right to continue to draw the fees. Knowingly charging clients a fee without a compliant ongoing fee arrangement may expose you to refunds and other penalties. You also need to keep in mind that where you have agreements with clients under which they pay you a fee or you receive a fee and you agree to provide them with services such as an annual review, you really need to make sure those services are provided and that you keep records. Our regulator is actively targeting advisors who promise such services but didn't deliver them, or who don't have adequate records that they did deliver them. So if you promise clients an annual review, make sure you do it and make sure you have records. There are some other rules under FOFA that you need to be aware of, but which we won't have time to go into detail on here. Of course, it's all outlined in the manual. So you probably know that there are restrictions on the revenue that you can receive under the conflicted remuneration rules. This includes the rule that you cannot receive any soft dollar or non-monetary benefits with a value over $300, which may influence your advice. And you must keep a register of any benefits below this amount which you do receive and keep. As always, there are exemptions and details around the rule, so please look at the manual and reach out for help if you need it. Under what's known as the conflicts priority rule, where a conflict exists between your interests and a client's interests, you must prefer the client's interest. Disclosure alone is not sufficient. And again, this is another area where the bar has been raised by the FOFA rules. And finally, you need to keep in mind that if a client has borrowed money to invest, you cannot charge an asset-based fee on those assets. So, for example, if a client has taken a loan to buy a share portfolio, you can't charge them a fee for advice based on a percentage of that portfolio. So So why is this? The idea of this rule is to try and prevent advisors from convincing clients to gear up and borrow for investment where that advisor is conflicted because they stand to gain from the increased portfolio size through an increased fee. So obviously, before you can give advice, you need someone to give the advice to. So you're probably going to be doing some marketing. Marketing can be a risky area itself, so here are a few things to keep front of mind. Firstly, any marketing material that you want to use needs to be pre-approved for use by Synchron. This is to help us manage risks around things like misleading statements, correctly referencing Synchron, our relationship and your authority from Synchron, and making sure that you're not using any prohibited phrases. This process is much quicker if you take the time before sending it to us to make sure it's all in order. We're happy to help, but if there's a lot for us to fix, obviously it takes longer. There's guidance in the manual, but here are a few of the main points.
Certain words or phrases cannot be used, including independent. And you need to be extremely careful with words like free, guaranteed, no risk, and other absolute phrases like these. Few things in life are absolute, and if you promise free and it's not absolutely 100% free, then you could find yourself in trouble. It's best to avoid these phrases. Use may or could instead of will, as in strategies that could help you increase your superannuation balance, rather than will increase your super balance. If you have other businesses that you run outside of Synchron-related services, make sure you keep the lines clear. If you are a mortgage broker, for example, make sure you're marketing for mortgage broking, never mention Synchron.
Synchron has particular rules in place around advice on direct property investments. Put simply, you're not permitted to advise clients to invest in a particular piece of direct property. Because of this, you must not market your services, say in a conjunction with a property developer or a real estate agent, particularly in relation to a client using their superannuation to buy property. This can be a risky investment area, and you need to take care to make sure that advice that you're not giving is not attributed to you. You should also keep in mind, particularly with self-managed super funds, what's known as the sole purpose test. The super fund can only be used for legitimate investment purposes, and it can't be used, say, to transfer a client's personal property to manage tax obligations. When marketing, you should also keep in mind, particularly if you're planning to do any cold calling or cold contacts, the Spam Act and the Do Not Call Register Act prevent you from sending unsolicited commercial electronic messages or from cold calling phone numbers without first checking the Do Not Call register. Now, this can be done online at donotcall.gov.au. So, if you have an email message you'd like to send out, you first need to have the consent of the owner of the email. The email message also needs to identify who you are and give the client options for opting out of future communications. There are fairly large fines under the law for spam contacts, so we recommend you be very careful.
Now I just want to touch on referrals. We recognise that referrals can be a useful way to build relationships, obtain new clients, make some additional revenue. But there are a couple of things that we do need to be made aware of. Firstly, disclosure. Any money or other benefits being passed between you and another party in relation to client business needs to be disclosed in your statements of advice. This includes where you pay a fee to another party and where you receive a fee. If you can put in a dollar amount, please do so. Otherwise, explain how the fee is calculated, for instance, as a percentage. The other thing to keep in mind with referrals is to keep them at arm's length. In some cases, this is also called a bear referral. The idea of the bear or arm's length referral is so that you and Synchron don't become liable for the advice that the other party gives by being too involved. So for instance, If you recommend a client see a real estate agent in relation to buying a property, but you go along to their meetings, agree with the advice the estate agent is giving, and also receive a fee, then it's pretty clear to the client that you're standing behind that advice. If the investment goes pear-shaped, you could be sued, and Synchron's PI insurance probably won't cover you because if it's to do with a product that's not on our approved product list. FOSS and the regulator will generally implicate the financial ombudsman service that is, and the regulator will generally implicate you in the advice in these situations.
Okay, so we've spent quite a bit of time on financial advice, given that's the most important thing that we do. But there are a few other rules and regulations that it's worthwhile you knowing about. We'll start with anti-money laundering. So when you arrange for a client to access a financial product, such as an insurance policy or a financial investment, you fall within anti-money laundering regulations. Certain information needs to be collected from the client in these situations and verified from other information, such as identification. Usually this is done via the product provider's application process. You must also be aware, though, of what's called ongoing client due diligence. What this means is that if you form a suspicion that a client is not who they claim to be, or that they may be involved in some kind of financial crime, you are obligated to report it to compliance, and we are obligated to report to the relevant regulators. A quick note on privacy. When you collect personal information from individuals, you need to make sure of a couple of things. You can only collect personal information that you need to have. For us, this is very broad because we need to do our fact finders in order to comply with the best interest duty. We need to collect health sensitive information for insurance applications and so on. When you have collected information, you need to protect it. This means ensuring that sensitive information can't be accessed by people who don't need to access it, either in hard copy or on computers. Also remember that you can't just use client personal information for other purposes other than what they provided it for, like marketing. We spoke about spam emailing before. Your best bet if you'd like to send things to clients is to collect the client's consent to send them marketing material, maybe when you're first engaging with them, and make a good file note of the consent that you've received. Now, since the 1st of January 2016, it's been a requirement for providers of what is called tax financial advice to be registered with the Tax Practitioners Board, or TPB. Now, the definition of this term, tax financial advice, is broad, and the board have clearly said to us that they don't see how any person who is working as a financial planner or insurance advisor could do their job without giving tax financial advice, and therefore being registered. So you need to be aware of this. Significantly, this is not an Australian Financial Services Licence rule. So although Synchron can help you where we can, this is an individual responsibility between you as the advisor and the Tax Practitioners Board. And they won't even necessarily share information with Synchron as your licensee. So you should refer to the Tax Practitioners Board website for information on how you register. Once registered, keep in mind that you also need to comply with the Tax Practitioners Board Code of Conduct. It's on their website and we've got a link in our compliance manual. Look, mostly the rules are very similar to the rules you already follow under the ASIC regime. They've tried to harmonise them where they can, but it's worth giving them a read, particularly if you are new to the industry. So, from time to time, things are going to go wrong, even in the best managed business. That's the reality. Our goal is never perfection because that's unachievable. Our goal is making sure that we are learning from our mistakes, at the same time ensuring clients are not harmed by our mistakes, and also ensuring that our regulatory reporting obligations are being met. So we've got strict regulatory obligations on us as a licensee to manage complaints and breaches and to report to the regulator where there are significant breaches or complaints. Where something goes wrong and we are open and transparent with the regulator, they take a much more collaborative approach with us. If we don't report, or if we try to cover up issues, they throw the book at us. Synchron Compliance use a very same principle in our internal management of complaints and breaches. If you think that something has gone wrong, you think regulations might have been breached, you need to inform Synchron immediately. If a client lodges a complaint, you need to tell us. If you're ever in doubt about whether a particular event or problem needs to be raised with us, raise it. If there's something that's keeping you awake at night, share it. You can always err on the side of reporting more. Keep in mind that our processes for managing these events are not geared towards assigning blame. No one takes pleasure in doling out punishment. Our goal in every case is fixing the problem, figuring out why it happened, and preventing it from happening again. Keep in mind when thinking about reporting that you're entitled to whistleblower protection on reports you make as well. So if you would like to remain anonymous, you can do so. And also let us know if you would like your identity protected as we manage any issue that you report to us.
I'd like to end on a more cheery note than that, so I'll say this. Welcome to Synchron. We look forward to a long and fruitful relationship with you. Synchron Compliance is here to manage Synchron's regulatory risk, but also to help you manage yours. It's to protect you as well as to protect us. As we said up front, we recognise there is a lot to be on top of. You're not expected to know it all off by heart. You are expected to look for help when you need it though. Take the time to check the Authorised Representatives Manual, read the emails that come from head office, and attend the PD days. They're a lot of fun and you'll learn an awful lot out of them. And always keep the client's interest at the heart of everything you do. To put it crudely, look after the client, the money will look after itself. Thank you for your attention. Please complete the questionnaire and return it to head office.